Hi, my name is Arati and I'm a journalist at MediaNama. I'm delighted to welcome you all to the research presentations for the 2022 cohort of the Meta India Tech Scholars. Meta launched the program to provide a research and mentorship platform to law students who are keen to engage on contemporary questions of technology, law, and policy. The law firm Shardul Amarchand Mangaldas Co is supporting the program as a knowledge partner. Through this series, the scholars will show us how specific policy choices in the technology sector influence and impact India's tryst with the internet. For today's showcase, I'm delighted to introduce you to Anish. Anish is a final year law student currently studying at the National University of Juridical Sciences in Kolkata. Hailing from the city of Mumbai, his life and passions revolve around the three cardinal P's: politics, poetry, and paneer. And when he's not obsessing over Chelsea's latest football game, he can be seen vociferously debating the state of global affairs. Although Anish believes himself to be technologically inept, he is passionate about tech policy, especially its interplay with constitutional law principles. He's particularly interested in the governance of speech online, and his research project under this program revolves around the regulation of synthetic media, specifically deepfakes, in the context of its use as a tool for disinformation. So I look forward to hearing from you, Anish, and thank you for being here today.
Thanks, Aarti, for that introduction. Let me just share my PPT. So, hi, everyone. The topic of my presentation is identifying responsible regulation of deepfakes by social media companies. So, there's a very famous Hindi quote which is called "Aankho dekhi," which essentially means seeing is believing. And this is a very apt quote which encapsulate the interesting and the scary part about deepfakes, which is that we are transitioning slowly into a time where we can no longer place reliance and trust on what we see or what we hear online. So, what exactly is deepfakes? Deepfakes, very simply put, is a technology which uses artificial intelligence to synthetically alter any form of media, that being photos or videos or audio. And while there is a lot of literature which is surrounding the impact of deepfakes, my paper specifically talks about how responsible regulation and frameworks for responsible regulations can be created by social media companies for the regulation of this technology. So when we look at the impact of deepfakes, it can be brought into two major prongs. It can have an impact on the individual, and it can have an impact on the society. When we talk about the individual impacts of deepfakes, we have predominantly seen it being used in the context of deepfake pornography and for creation of defamatory contents, which often violate some of the most basic tenets of privacy and dignity. But when we look at the broader impacts of deepfakes in the society, it is still at a very nascent stage and has been touted to be used as a potential tool for disinformation. And its uses in that context can be several folds, whether in cases of election tampering, whether in cases of creating public order disturbances, and the list goes on. So once we know that this is what the technology is, and this is what the impact or the potential impact of this technology is, we then move forward to identifying how we can create a framework for the regulation of this technology, for which we need to assess three different things. The first thing which we need to assess is what current regulatory obligation exists on these social media companies vis-a-vis this technology, which is deepfake. The second thing is what is the threat assessment of these deepfakes, whether the possibility of it being used correlates with the probability of it being used as a vehicle of disinformation. And the last thing is understanding the limits of these companies to moderate content online. So when we go to the first prong of this approach, which is the regulatory obligations, the first and the most foremost piece of regulation is the IT Rules 2021, which has been brought under the IT Act 2000, which at first glance covers all bases with regards to the potential misuse of deepfakes online, whether it's for defamation, whether it's for creating sexualized content, whether it's for impersonation online. what we need to look here is to go beyond these legislation and see what is the inherent incentive structures which has been created by this piece of legislation. When I mean by incentive structure, we have a fundamental dilemma when we're trying to regulate any sort of speech online. If there is too much of regulation, it can lead to a potential censorship of speech. If there's too little of regulation, it often leads to an ineffective zones where where harmful content still looms large. So when we look at the structure that exists in India, one particular clause comes into the play, which is 31N, recently inserted in the IT rules, by which the government has brought in obligation on these social media companies to respect the fundamental rights of its citizens, particularly Article 14, Article 21, Article 19, which means that there is an added obligation on the social media companies to take a more pro-speech approach and to ensure that they are not censoring the speech of its users. Sorry. What it essentially leads to is that idea that there is an inherent incentive over these companies to protect speech, even if it comes off on the trade-off of reduced effectiveness when it comes in regulation of deepfakes, especially when you're regulating deepfakes through self-regulation of content and not when it is reported by, let's say, a user or by an authority. So once we know this, we can also see its counterpart, which exists in a lot of European countries. Let's say Germany, which has passed an Online Regulation Act, wherein harmful content, if not taken off by the social media company within 48 hours, will make them liable for punishment, which is an example of the other end of the spectrum, which is a more pro-effective approach rather than a pro-speech approach. Once we have taken cognizance of the same, we come to the next prong of our three-pronged approach, which is understanding the threat assessment of deepfakes. While there has been a lot of opinions about the potential misuse of this technology, we need to understand what is the probable impact of this technology right now, and for which we need to remember an axiom which says that all disinformation actors are essentially rational actors. What do we mean by this? It simply means that disinformation actors will employ that tool as a vehicle for disinformation, which reaches the most amount of people, influence the most amount of people, and does so at a minimum of cost. So we need to look at the persuasive capacity of deepfakes, we need to look at the cost of deployment, and we need to look at the risk of detection. Currently, deepfakes, as against its other counterparts, which are cheap fakes, which are chiefly crafted fake news or memes or tweets, which have been used as a popular vehicle for disinformation, particularly if we look at the Cambridge Analytica scandal, we see that deepfakes is comparatively much more expensive to deploy and create. For example, it requires around 30,000 data sets to create a high definition deepfakes, which costs around $4,000 right now, which means that it is much more expensive to create deepfakes as of now, and also that the risk of detection of deepfakes is pretty high because we have deepfake detection technology which is being invested by these companies, and as these detection technology increases, so do deepfakes. So do the creators of deepfakes need to invest more in bringing more novel data sets to evade these technologies, making the process even more expensive. But while the current status quo reveals that the probability of deepfakes as a vehicle for disinformation is low right now, there are causes to be concerned for, especially because of two reasons. The first reason is that there is continual development of this technology as we speak of, making it much more cheaper to create more sophisticated deepfakes, and to employ it on scale. And the second being is the low level of digital literacy in a country like India, where it is very easy to persuade people using fake contents. But having said that, we come to the last prong of this approach, which is identifying the limits of content moderation. When we think about content moderation, we often try and have this tendency to compare it with a utopian form of offline justice. However, this is not often possible, A, because of two major reasons. A, being the sheer scale of content moderation, which exists right now. To put it in perspective, Facebook or Meta deals with more free speech cases in a day than the entirety of the United States Supreme Court in its history. And also the context that deepfakes, even though can be identified, regulation of these deepfakes becomes tricky, especially because exceptions of parody and satire exist, which makes it highly subjective. But what we also see, and a very pertinent question which comes about here, is why social media companies needs to bear the onus or the primary onus for the regulation of deepfakes. And that is because of, firstly, the time-sensitive nature of deepfakes. Because given in the context, let's say, of defamation or of election tampering or of a public order situation, content needs to be the deepfake content needs to be taken down immediately and in a time sensitive manner to reduce its impact. And also the second point being that assigning of liability of the creator of deepfakes is extremely difficult, especially when we are talking about a public platform like Meta or public platform like Twitter. Once we have set these limitations, it is important to remember certain principles for creating a more effective regulation. One of them is embracing the idea of flexibility and reducing the idea of formalism within content moderation, and creating obligation based on the limitations of these companies to regulate content online. So having taken cognizance of these three approaches, we come to the main part, which is the recommendations. So while there is no single panacea to the problems of deepfakes or a single silver bullet, there are a lot of ordinary bullets, as I call it, to reduce the impact of deepfakes online. And it can be brought in three major prongs. The first is technical solutions, the second is social solutions, and the third is regulatory solutions. When we look at technical solutions, and whether it's the creation of deepfakes, whether it's the detection of deepfakes, all it requires is more data sets. So creation of a repository of data sets by these major companies, these major social media companies, is extremely vital to create better anti-deepfake detection technologies and also deploying it en masse. What it also requires is a continual research to upgrade these technologies so that they can always stay ahead of the creators of deepfakes. The second prong is a more social approach. It is important to remember that content are not just circulated on a public platform like Facebook or Twitter, but can also be circulated in a private platform, let's say like WhatsApp or Messenger, where content moderation has a very limited role to play. In this instance, it's extremely important that the digital literacy of the country needs to be increased, and people are aware that such a content exists. And oftentimes, artificial intelligence and vehicles like memes and GIFs can be used to educate and enlighten people at a broader scale. It is also important to educate vulnerable stakeholders, especially, let's say, journalists or people in power or public people who are likely to be targeted by this technology, in knowing how to report if such a thing arises, and knowing how to file a complaint if they ever fall a victim to the misuse of this technology. And lastly, when we look at the regulatory approach, there can be several regulatory approaches which can be taken up. One very common approach that can be common and effective approach that can be taken up is creating a disclaimers for any sort of content which is deepfakes, essentially telling people that, hey, this piece of media is a deepfake, and anyone failing to not highlight the same will be liable for a takedown, and also creating different threshold for different sort of deepfakes, especially if it is relating to a political figure, or if it is relating to a time, to a sensitive time, let's say elections, wherein any form of media which is uh, relating to a political figure or someone who's standing for elections can be subjected to a higher threshold of scrutiny. And having said that, these recommendations needs to be incorporated to create a more holistic regulatory framework for the regulation of deepfakes. And with that, I rest my presentation. Thank you.
All right, thank you so much for that, Anish. That was a really great kind of overview of what more platforms can do in the current regulatory environment to sort of combat deepfakes and figure out how to take them down in time. And I think it's sort of a pertinent policy issue right now. We've seen the Prime Minister talk about it, we've seen actresses talk about it. Lots of famous and probably not so famous people are being impacted by these technologies. And so, thinking about ways in which platforms can take better steps, given that they're often accused of not doing very much, is sort of a good first step. But I think the bigger question that I had in all of this is essentially we're looking at platforms through the prism of the IT rules, right? And non-compliance with the IT rules is ultimately tied to loss of safe harbor. And this is something that both the various senior ministry representatives have spoken about as well, that if platforms fail to take down deepfakes on time within the stipulated timelines, they will lose safe harbor in India at least. So, even if you build these really great frameworks that do a good job, and if something slips through the cracks and it catches into the sort of attention of the government, you could still very well, despite your best efforts, lose safe harbor. So instead of sort of taking the IT rules as de facto in a sort of hypothetical scenario, are there different ways that we could frame the parent laws or the parent legislations that deal with platform governance, so that this threat isn't always there? How would you go about it? Of course, this is totally hypothetical and conjectural and totally based on your wish list of what India's tech policy sector could look like. But how do we change the parent law so that this negative threat isn't there, and so that platforms actually take their obligations of balancing free speech against content takedown seriously as well?
Uh, Thank you, Aarti, for that question. I think the first thing which we need to remember when we're looking at content takedowns, especially with IT rules, and as I think several ministers have also spoken about it, is that when the content is reported, and this is a very important clarification here, is that there can be two ways in which content is taken down. One is when it is reported either by the user or by an authority, which is, let's say, the government, or let's say the court in question. And there is another way in which content can be taken down, which is the social media themselves taking a more proactive self-regulatory uh, proactive step, which is essentially self-regulating the content here. So when we see the news and the threat of uh, losing the loss of safe harbor, we are only talking about when these contents are reported and brought to the notice of these social media companies, which is essentially a very small part of the problem. Because a larger problem is that there is so many content which is online, and which it's very difficult for people to report, a, if it is not pertaining to them personally, and also because it's the sheer scale of it, that it's not always possible for social media companies, like you said, like there'll always be something which is slipping out of the cracks. So on these especially, a, it is important to take a more collaborative approach with the government, because the government can take also has the sheer scale and the capacity to educate users about things which is existing right now, and also not antagonizing social media companies, because at the end is what needs to be taken cognizance of is that they have limited capacity, and it's not something which they can do and not doing. Rather, it's something which is important, which rather it's something which needs to be taken care of in a more how should I put it, in a more collaborative form. And I think that is something which could be taken off differently. And again, I think more infrastructure could be built wherein not just the bigger companies which are existing, but also smaller social media companies. Because when we look at the IT rules, it's not just subjecting it to the subjecting companies which are as big as, let's say, Meta or Twitter, but also smaller companies which may also face similar problems, but may not have the capacity to regulate content in the same way as these bigger companies, where support could be provided by these agencies for essentially taking down content. And I think that could be one. Obviously, this is hypothetical,
Yeah.
so I think
Okay.
something similar
So
could be
just to
taken
sort
up.
of summarize what you're essentially saying is that the number of the threat of safe harbor is really pertaining to a very small set of cases where the content is actually reported to the
Right.
platform. And B, when we're looking at regulating overall and looking at regulatory imagination, we need to be more collaborative and not necessarily penalize without understanding the consequences. Is that the
Right. Right.
gist? Okay, great. So on that note, there's actually there was a recent op-ed that came out in a national daily, and we had some very senior sort of consultants to the government recommending different ways in which the government and industry can work together to ensure that deepfakes are regulated. And one of the kind of recommendations that was given, which was that companies that use general adversarial networks or deepfake applications essentially could say register and disclose those use cases and technologies with an oversight body that would then check if they're being ethically used and then sort of approve their usage in the Indian market, so to speak. Now, do you think a sort of verification framework like this could kind of help social media platforms because they might be able to say, oh, there's like a wide list of good companies that are doing good things in a blacklist? Or do you see a verification process like this having its own consequences when it comes to sort of looking at the expansion of technology and
Right.
from regulation itself?
So I'm not entirely sure how this would work out personally for me, because a you don't know what sort of application these companies are into. So let's say a company is just creating deepfakes, then maybe an oversight mechanism could work. But let's say a company creates an app which is able to make deepfakes, then you obviously can't have the oversight board taking cognizance of every single uh, media which is created out of that application. Let's say something as simple as face swap, right? It's a technology which has been created by a company. Now, how I use that technology or how a common user uses that technology can be very varied. So it is not feasible then to have uh, an oversight mechanism for each and every single user who is creating that a media out of it. And also secondly, what could be then done is creating, let's say, a sort of a gatekeeper right at the posting of a media. So rather than having an oversight mechanism which is on the application, on the creation of a media, but rather when the media is uploaded online. So let's say when we have media which has ads in it, there is a mandatory requirement that there has to be a disclosure that this form of media is basically sponsored.
Yeah.
In in a similar breath, we can have a requirement where media which is synthetically altered has the disclaimer that this media has been synthetically altered or this media is a deepfake.
Hmm.
What it does done is it gently nudges the users that they know that, hey, this is not entirely true, that this is in fact a synthetic media, which also reduces its impact on its persuasive capacity that it may have, and which is a cause of concern.
Right. Great. And you're talking about essentially the creator of the media self-declaring, right, in this case.
Right, right. Yeah.
Okay. All right, great. Well, thank you so much, Anish. This was a great conversation. And if you'd like to read more about Anish's work, please head to MediaNama's website, where you can find this presentation as well as the presentations of all the other scholars participating in this year's cohort. You can also find them on our YouTube channel as well. Thank you so much, Anish. Have a great
Thank
day.
you, Arti. You too.